May it please the Court, my name is James Carnes. I'm the attorney for the Huron and Eastern Railway. This case is here on our application for leave to appeal a decision of the Court of Appeals which left in place plaintiff's claims related to vegetation allegedly obstructing a driver's view at a grade crossing. This case involved a collision between a vehicle driven by Mr. Corl and a locomotive from the Huron and Eastern Railway. The court basically left in place the vegetation claim, and we asked for leave to appeal on two issues. One was the fact that the court more or less acknowledged that the physical characteristics of the crossing were such that the view was not obstructed, but nevertheless determined there was a fact issue as to whether that was a cause. And the second issue, which the court asked us to address here today, which was whether this conflicted with the prior Court of Appeals decision in the Paddock case. So we were asked to address two issues. One, did the lower court decision here conflict with Paddock? And then two, was Paddock correctly decided in the first instance? Now, interestingly, if I'm reading the briefs correctly, both sides seem to agree that Paddock was decided correctly. The issue seems to be that plaintiff, much like the Court of Appeals, thinks that this case is distinguishable from Paddock and not in conflict. And I would argue that it's not. In Paddock, the issue was, much like what we had here, a driver who was involved in the estate of a driver who was involved in an automobile accident at a crossing. Part of that claim, and the claims in Paddock were identical almost to the claims made here, but one of the claims there was that there was vegetation that should have been cleared by the railroad because it was obstructing the view of the driver. What the Paddock court said, and the way it was framed in the appellate court, was that there was no duty. The issue that got in front of the appellate court was, is there a duty to petition the road authority to create what's called a clear vision area and remove that vegetation? So in the Court of Appeals here, the court took a look at that and said that's different. The Paddock case is looking at a duty to petition the road authority.
We kind of know what the case says.
Okay.
Why do you win? Well, let me ask the threshold question. You both agree that Paddock was properly decided. Why do we care about this case? What is its jurisprudential significance?
Well, I think the problem here is, Judge, if Paddock is correctly decided, then Paddock is in direct conflict with the case here.
Why does that make it jurisprudentially significant? If the controlling law is correct, that suggests this is a one-off case, right? that it is itself, it's a question of whether the application was correct or not.
Well, what I would say is we have two Court of Appeals decisions now that directly conflict with each other. We have this Corl case, which says that a railroad has a duty to remove vegetation or create a clear vision area, and we have Paddock, which says a railroad has no such.
Corl's unpublished.
Correct.
Only Paddock's published.
Correct.
It's the only one that has precedential value.
Correct.
And?
Well, I understand, Your Honor, but we moved to appeal this case, and when we were asked to, when we appealed this case, we didn't appeal on the basis.
You're here, but I wanted at least to ask you, is this a case that has any generalizable value beyond itself? What will this? How will this affect the universe if you both agree that Paddock is properly decided?
Well, I guess
what is presidential.
What I would say, Your Honor, is that when we appealed this case, I was not under the impression we both agreed that Paddock was correctly decided.
Either was I.
Okay. And so, and I guess getting back to the other point, the issue then is we have, and I understand it's unreported, but we're still in a situation where the court below has held that we are now responsible for creating clear vision areas where Paddock.
So the only reason you're here now is error correction.
Correct.
Okay.
Correct.
Okay, I understand.
And so I don't think there's any way to read Paddock as being consistent with the Corl case, because underlying the Paddock case was, even though it said there's no duty to petition the road authority to create a clear vision area, the basis for that decision was that there was no underlying duty to create a clear vision area in the first place.
Why Why would that be? Why are those two things not entirely consistent?
Well, because as the court stated in Paddock, I'll make sure I say it correctly, where a railroad has no duty to do a certain act, it also has no duty to petition for someone else to do that act.
Oh, okay, so maybe the jurisprudential significance here is that piece, whether you have the duty to do the particular act, which of course wasn't at issue really in
Paddock.
Paddock.
Paddock was not postured as a common law clearance case. It was predicated on the assumption that the statute required something that the court found it didn't require. Namely, you had to the railroad had to petition to get the order, right?
Well, I don't know that I agree that's how that was postured. I mean, their claim there was the same claim here, which was simply a railroad has a duty to remove vegetation. I think.
Yeah, but under the statute.
I'm not sure
Under
that's
the
right.
statute, not the common law.
I think what the court was saying that because of the statute, there was no common law duty to remove vegetation.
Show me
but-
the language.
Well,
I don't read Paddock as saying that. Show me.
I would say Paddock is not that clear. I mean, it doesn't come out and
I
say
would
that.
say that's fair.
Say that directly, but the claim in Paddock, if you look at how Paddock is postured, and you look at what the plaintiff was claiming, the plaintiff wasn't making a claim, as I read the case, under the statute. The plaintiff was making the same claim that you would make under common law, which is a railroad has a...
Except they didn't. That's the problem.
They didn't.
They made it under the statute. The court was actually looking at whether the statute compelled a result, and because it said that the effort had to be initiated by the government, the plaintiff was saying, well, you had an obligation to petition to get the order. And the court said no.
No obligation.
I read Paddock, Your Honor, as they're asking, their claim in Paddock was a railroad has a duty to clear obstructing vegetation.
I think we can agree to disagree about what
Yeah,
Paddock
yes.
says. But,
Well, go ahead, Bridget.
I was
Sorry.
just going to ask a separate question. Is it your position that in light of 462.317, a railroad has no responsibility whatsoever for the degree of visibility provided at a railroad crossing?
Correct.
Not at all.
That is our position.
Then all right, I got it. I thought so.
Okay.
So how does that square with the deposition testimony of your client's employees, which were identified in your brief, that they cleared the vegetation from the crossing a few weeks before the incident? Why are they doing that?
Why do they maintain vegetation at
Yeah.
crossings?
Why do they do that?
Good citizens.
They just care?
They do, and part of the problem, Your Honor, of course they do. I mean, I guess this is how I would answer that. But part of the issue here is this is part of a larger scheme, and one of the things I mentioned in my brief was because we weren't looking at whether Paddock was correctly decided, and we were looking at Paddock and understood Paddock to mean that a railroad has no duty. In fact, I think the court says in Paddock that it is the duty of the road authority, not the railroad, to determine the need for a clear vision area. I mean, the way it works, however, is that MDOT goes through and they inspect these crossings, and they will issue orders pursuant to 432.301 for railroads to take corrective action, and railroads have to keep up and maintain vegetation or face consequences from MDOT, essentially.
But if there's been no determination by a road authority, the railroad doesn't have any obligation to do anything. So in this case, they were just doing it for what reason?
To maintain it so they're in compliance with MDOT.
Oh, because there was
A pre-existing order?
No, in other words, MDOT or a road authority will go through and make
I
determinations.
know that's what happens in general, and I
Right.
understand your view that unless that happens, you have no obligation. Was there such an order in this case?
No, not,
So
I
then
mean,
why were your employees, your client's employees, clearing the vegetation from this crossing?
so they wouldn't get hit with an order. I mean, they
But you
maintain
say
it.
there's no,
Order.
the MDOT doesn't have this jurisdiction unless there's a clear vision plan.
No, I don't think that's correct. I think under the railroad code that there are, powers were consolidated with MDOT to have jurisdiction over the railroad specific to grade crossing safety, and such that they're the ones tasked with determining whether or not a clear vision area or vegetation has to be cleared to allow a driver to have a better view of a train. And so if you also look under 462, I think it was .301, that MDOT has the power to go out and issue corrective action orders and determine whether there's deficiencies and a railroad has to comply with that, and then there would be penalties if they don't comply with that.
Okay. And your position is that that act abrogated the common law?
Correct.
And where's the language specifically abrogating the common law?
Well, I think if you look at, again, in Paddock, it said that it's the duty of the road authority, not the railroad, to determine the need for a clear vision area.
Under this statute.
Correct.
Okay, this is directed
Right.
at the government. This statute is not directed to the railroad.
Oh, I don't know that I agree with that. I think what the
Well,
statute,
then point me to the language.
well, I think what the statute does,
Just
is it-
tell me where to look.
well, I think the section itself, Your Honor, 462.317,
Specifically,
What language?
I kind of like words.
no, I understand, I'm trying to turn to it. It says if a road authority determines to establish a clear vision area, and then it talks about the railroad and road authority may agree in writing. I mean, it's directed to the railroad in the sense that it's giving
They
the,
have, if the government comes up with something, they have to agree with the government. Okay, that doesn't explain to me whether there's a freestanding common law obligation that the railroad bears.
well, I would say if the legislature places the duty to determine whether this vegetation needs to be cleared with the road authority, then the railroad no longer has that duty.
But it's not exclusive authority, right?
Well,
Why
I think
is
it is.
Why is it exclusive authority? Are you drawing all of that from 462.317?
I'm sorry, I didn't.
The exclusive authority idea comes from 462.317?
Well, if you look at the Railroad Code of 1993 as a whole and what its purpose was, it was comprehensive litigation. It was there to, legislation. Its purpose was to revise, consolidate, codify laws relating to the railroads, prescribe powers and duties of the state and local agencies and officials,
Not railroads.
and have the exercise, to exercise regulatory and police power over railroad companies.
Okay,
Yeah?
all that's directed to the government. Where does it say, even in the precatory language, where does it say, and to abrogate common law rules related to, I'm just trying to figure out.
Vegetation clearing.
I don't think it specifically says that. I mean, if you're asking me to point to a line in it where it says we specifically abrogate common law, I'd have to say it does not say that. But if you look at the law, the purpose of the law, and what it did and how it ended up working, and if you would look that there's not a single case since Paddock that has ever determined or said that a railroad has a common law duty to remove vegetation at a crossing. I mean, it's been understood since the Railroad Code and since Paddock that that's not a duty a railroad has. That's why there are no cases on this.
Okay. Anything else?
No, thank
You want to
you.
reserve the remainder of your time?
Your Honor, it's Philip Maxwell on behalf of the plaintiff. First, in Paddock, it was the plaintiff that pled the so-called clear vision statute. The plaintiff made a critical error in pleading in that case, and I know because I was the defense attorney on that case. They did not plead the common law duty, and that was the consequence. The defendant here has consistently conflated this so-called clear vision statute with the common law duty to maintain a safe crossing. These are two very different things. The clear vision statute, 462.317, is an isolated statute. The term clear vision is never defined, not in the statute, not in the Railroad Code, and not in case law. It applies, if you read the whole statute, to quadrants around a rail crossing that are not within the railroad right-of-way or the road commission's area of responsibility. Hence, it refers to acquisition of right-of-way, purchase and removal of buildings. This is a different creature entirely than the common law duty to maintain a safe crossing, which includes the duty to remove visual obstructions that are within the railroad's right-of-way. So we're dealing with two different things. Nowhere in the so-called clear vision statute does it specifically say that we are abrogating common law duties. Doesn't even refer to it.
Could I ask you, I mean, the fact that you now both agree that Paddock is properly decided, what resonance does this case have beyond itself?
None. Because the difference between Paddock in this case is that we pled the common law duty. And defendants have come forward, oh, no, the clear vision statute abrogated that duty. Of course it didn't. You can't do it. You can't erase common law. The legislature, by implication, which is what's being argued here. Because there's no specific reference here. This is 150 years of jurisprudence that defendants would erase as if by magic. It can't be done. There's no conflict with Paddock here. This is a different case. Here the plaintiff pled the common law duty and relies on it, and it is our position that the common law duty remains because this statute, the so-called clear vision statute, nowhere specifically references common law.
Apparently you do learn from the mistakes of others. I hadn't noticed that you were defense counsel in Paddock.
Younger.
But successful.
More hair in those days. Thank you, Your Honors. Unless there are other questions.
Do you have any rebuttal? Aren't you arguing? Come on. Aren't you arguing abrogation by implication?
I am, Your Honor. I am. And I think where common law and the statute conflicts, that it does abrogate the common law. And so our position here is, and this isn't a unique position to us in this.
Do we have any jurisprudence on abrogation of the common law that we ought to look at here?
I was trying to see, as I looked there, to see if I cited something specifically, and I don't see that.
Are you aware that how we usually treat abrogation of common law? Does it have to be explicit, or can it be inferential?
I have in here, Your Honor, that where common law, I mean, I have a case cited that says where common law conflicts, or where the statute conflicts with common law must yield to the statute.
But I don't even understand why they conflict. Why aren't the duties complementary? So what the statute gives you is a right to harness the government's power of eminent domain in order to be able to get rights to clear the vegetation, which you might not otherwise be able to acquire through, you know, the market forces or through people letting you on their property that you don't own in order to satisfy your common law duty to clear the vegetation.
I don't.
Seems complementary to me.
I understand your question, Your Honor. I guess I wouldn't agree with the premise that this is an eminent domain type statute. I think.
Doesn't it say that you get the right to, if you do it, then, I forget exactly where it is, but it says something about your ability to
acquire. I understand where yes, I understand where you're going with it, Your
Honor. Through the government's powers of essentially eminent domain.
Correct. But if you look at the initial part of that section, it talks about it being the the road authority having the power to determine or authority to determine when this area would be cleared. So in other words, to the extent the railroad had a duty before to determine what needs to be removed, that duty now lies with the road authority. In fact, I think we put in our brief the statute with the Railroad Code of 1993, the statute was actually changed to note that it went from an agreement between the railroad and road authority to giving the road authority the power to determine when these things need to be cleared.
Thank you. The case is submitted. The call is concluded.